Hello.
Hello, Yuvika.
Hello, Michael.
How are you?
I'm doing very well, thank you.
So this podcast is a bit different, as everyone can see. I'll remind our viewers that in the last podcast, Joe kept looking at me and saying, "This is your show. You're on the spot. This is you." Well, lo and behold, look what's happened. No, but seriously, he's on well-deserved holiday. We forced him to take a break.
But we have his blessing.
We have his blessings. He's going to be here because he's always here. You know that. He's never not here. Right. So he's observing tonight, not actually talking, which is very rare. This might be one of the greatest hits where he doesn't say anything. So we're going to have to compensate. And
we're going to call this podcast Wine with Mike. Is there?
And you.
Oh, okay. So Wine with Mike and Yuvi.
Yeah, it's not a Scotch-based podcast. It's a red wine-based podcast. We don't have the appropriate glasses for that. We apologize.
It's been a long day.
It really has. So it's going to be more of a subdued podcast.
Right.
So we're going to... Go ahead. No. You were going to say something.
I was just going to ask you, what are we going to talk about today?
Well, a lot of our viewers have been sending us comments and questions about the process, the procedure. They're very curious, not just about case law, because in a lot of our podcasts we talk about the outcome in this case, the outcome in that case. But tonight we're going to talk a little bit about the heavy lifting that goes into our wins.
Right.
And you've been doing a lot of heavy lifting recently.
Quite a lot, yeah.
Yeah, so we're going to talk about two particular types of applications, maybe three, that we often bring in sex assault trials with respect to either records or us getting our records in, because things have changed a lot since I started out as a lawyer. The gunslinging cowboy days are gone. Now there's so many hoops for defense lawyers. I think our viewers would like to hear about that heavy lifting.
Sure, there's no sandboxing a witness anymore, or there's no surprise.
Nothing's a surprise in sex assault trials anymore.
Not anymore. So the way you have to prepare these applications, and I'm going to try and make this as simple as possible, because they can be very complicated sometimes. We're dealing with text messages, we're dealing with prior relationships, or consensual activities, or non-consensual. There's just so much going on in a relationship, and I certainly was not there. So
well, but let's stop there.
Right.
Why all these hoops now versus just showing up at trial and cross-examining the hell out of a complainant?
Well, because we are trying to balance the complainant's privacy interest as well as an accused right to a fair trial. And it's a very tough job, I feel, at the end of the day, to have to decide, okay, privacy interests are at stake here, but at the same time, the accused has a right to cross-examine the complainant on relevant issues. So trying to balance both, it's important, and you cannot just come up and just guns blazing anymore in court.
So take us through a scenario. Client shows up, he's been charged, and the first thing they want to do often, but I have all these text messages, I have all these photos, I have all these Instagram messages, I have all this stuff. I think there's a lot in there that could help us. Can you just use it right away? No. But don't tell her about it. Let's just show up in trial. So
no.
What do you tell the client?
So we have to work with you. We have to develop what is the theory of the case. What are the allegations against you? Whatever we're going to use, how is it relevant to an issue at trial? If, let's say, hypothetically speaking, the complainant says in her statement, I had no relationship with this fellow. He's just some creep. I just don't like him. Let's just put it that way. And I've had no relationship with him. But I have these bunch of messages and text messages and pictures that are really intimate in nature. They're flirtatious. I may want to use them.
You're being so polite. Why don't you just say dick pics? Why don't you just say it? Okay?
No, I'm going to be nice. I'm going to be nice, and I'm going to put it nicely and sophisticatedly.
Okay, you be sophisticated. I'll be half Joe.
Right. You can channel Joseph.
I'll channel a bit of Joseph. Okay. You be ladylike. I'll be Joe.
No, but so no matter what you have, it has to be relevant. It has to be specific to an issue at trial.
According to who?
What do you mean?
Relevant according to who?
That's just the procedure. That's the case law.
Yeah, but who decides that? Who decides this is relevant or not?
That's the judge, the
so
trial judge.
So tell us how you get to that point where a judge has to decide.
It's a long process, a very long process. So let's say you're my client, you come up to me with a lot of stuff. I have to sit with you and review the disclosure first. I have to see what the allegations are. I have to then determine what is your story. Like what is it that you want to convey really happened? Did it happen? Did it not happen? What is the defense of the case? And based on what I hear from you and based on what materials you have provided, then we have to create, a narrative in the sense that whatever you want us to use, it has to make sense. It has to go to the allegation. It has to do something.
It's about storytelling at the end of the day.
It is a storytelling at the end of the day. And that's why it's very important for the clients to be able to, provide all of these items well in advance of the trial, well in advance, months in advance, because sometimes these applications can be this thick sometimes because of all the statements that we have, the pictures, the messages are thousands of pages.
Slow down, you're talking so fast I can hardly keep up.
My bad, I've been told I speak really fast. I'm sorry?
Then that's what Joe says.
Yeah, he says that to me, so it's my turn.
Okay, all right, I'll speak slowly so you can understand.
I'll try my best. I still don't understand all this stuff. It's crazy.
Basically, it all has to make sense. Just to put it nicely, it all has to make sense. It has to be relevant. You cannot just show me a picture and be like, we have to use this and it's going to make sense. No. Why does it make sense? How does it make sense? Is it relevant?
Okay. So
Am
what
I making
happened?
sense?
You're making sense. That's a lot of, you use sense a lot there, but that's fine.
Right.
So
once the applications are prepared, that we have something. The applications are heard in 2 stages.
Wait, stop. What's involved in preparing the app? Tell me the nuts and bolts, what you've been doing for the past 3 nights where you say you haven't slept. What is physically involved in these applications? Take the readers through it, the listeners through it.
So let's say, there are 2 aspects of every application. One is the 276, one is the 278 application.
And what does that refer to?
276 is basically prior sexual history.
It's also a section of the criminal code, just so they know. Just
so everybody knows. So 276 is basically anything which is not the subject matter of the offense. So let's say you've been charged with allegedly sexually assaulting or just, touching somebody without their consent.
Right.
But you want to talk about, hey, we had a relationship for 10 years. This is how we communicated consent. We've spent plenty of nights together doing blah, 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 blah,
ABC.
blah, blah. Now, that's not the subject matter of the offense.
Right.
That's not the subject matter. So for me to be able to ask the complainant questions about it, I have to go and, prepare what's called a 276. I need permission from the judge as to why is it necessary for me to ask questions to the complainant, or rather put to her about their history. And not just that, it's also relevant as to you being able to talk about it as an accused.
Right, when you're testifying.
When you're testifying, because you cannot just sit up there, and just talk whatever you want.
You can't just say, well, we like to do ABC in our relationship.
No, you cannot do that. You need prior approval from a judge, and this is why it's so important for us to know what was your relationship like. How long ago do you go? And when I mentioned earlier that I wasn't there, what I meant was, it's your relationship. Right? When you are coming to a lawyer, you should be able to explain your life with this individual. And that's how we prepare prior sexual history. Is it relevant for me to ask those questions? Why do I want to ask those questions? In what context do I want to ask about her prior history?
Do you find a lot of clients say, what? I thought you were going to do all the work.
Well, sometimes. Yes, but you have to work with your lawyer. You have to. There is, like I said, I was not there. I do not know what to make heads or tails out of the messages or pictures that you give me, unless and until you sit with me and you explain to me, this is
the context of each.
This is why
inappropriate picture.
And it's like, we determine what's relevant and what's not relevant. Yeah, our expertise will eventually come in and kick in as to why we want to use a certain thing. But you have to be able to explain. For example, if you're giving me a picture of yourself with the complainant just at a birthday party, for example, why is it relevant? How is it relevant?
How is it part of the story?
If for example, if she says that I stopped speaking with him and I have nothing to do with him, let's say March 2020, I stopped talking to him. But this picture is from June 2020.
Right.
I want to use that.
Why?
Because I want to impeach her.
Exactly.
Right. Because I know that the complainant is not being honest about certain things. And when we know how many...
Yes, we do. So to use Joseph's favorite phrase, let's break this down.
Let's break this
I was
down
dying
further.
to use that, folks. He says that all the time. So, clients come in, you're retained, you've put his or her case, well, typically his case, off for a number of weeks after the first appearance to get that disclosure. You get the disclosure. Typically a lot is missing. You ask for further disclosure. At some point it arrives. You review it, have the send it to the client to review. Then you have this meeting where you sit, and the client's already dropped gigabytes of stuff on you, typically this photo, that photo, this text message, here's my phone. You then have this meeting where you kind of craft the narrative with the client.
Right.
So we've done that first heavy lifting. What's next?
Well, you have to go through the stages. So
tell us. No, they don't know the stages.
Wonderful.
This is your favorite part.
Like, before I even go through the stages, I want to break this down even further. I don't want to go and talk about what happens in court.
No, we don't want to get into court yet.
Since we're talking about 276, I did refer a little bit to 278, and
Explain
I just want to talk a little bit about that as well before I tell you what happens in court. So
another section of the criminal code.
Another section of the criminal code. So 278 is it's in relation to records of the complainant. So let's say you have messages, you have pictures in your possession that the complainant could have a reasonable expectation of privacy in. So let's say we have these messages and they contain some really sensitive pictures of the complainant. Well, you don't. It's not rocket science. Yes, she does have privacy interest in it, and I do need permission from the judge as to why I want to use it, how I want to use it, and why is it relevant.
So pause, as Joe says. Joe, we love you. That's why I'm...
Yes.
So one side of the potential application is for records that are in our possession, right, that we have to disclose. Another side of it is records that belonged to the complainant, and either she has in her possession or we have in our possession, or both, right? Okay, so... Or
it could be records in possession of a third party.
I was just about to add that.
Let's say,
give us an example of a third party record.
Let's say the complainant is visiting her therapist, and you want to know what's being discussed in therapy. You have to, and you're like, maybe it's relevant, or let's say you think it's relevant, you want to go after it. You have to file an application explaining why it's relevant. What is it that you want to use it for? How do you want to use it? And the inquiry does not really stop there. Even if you are able to get those records, let's say you get the therapist to provide the records, you still have to go through, why the two stages that I'm going to explain to you just now. Like, you still have to explain the relevance of it. You still have to go through stage 1. You still have to go through stage 2. Some of the records could be sexual in nature. So,
do you ever get those records admitted?
Well, I haven't really gone after therapy records yet. I don't necessarily see, unless the need arises.
Of course.
I don't necessarily see the need to apply for third-party records just yet in any of my cases so far. But should a need arise, and if I have to use it, I'm going to apply for it.
Do you have an example of a need? Because most people are going to go nuts. Not our audience. I'm just saying most people are going to say, you have no right to look at my therapist records, or you have no right to look at my CAS records involving my children.
Sometimes it could be relevant. Imagine you're dealing with a complainant who's not an adult, but there are some CAS activities involved previously in which the way the complainant, or for whatever reason the CAS is involved, and the complainant who's the child has described their relationship with the accused to be really good, but for whatever reason he's charged with a criminal offense. Maybe I wanna do see that. I want to see how long ago this happened. I want to see, is there an overlap in what she's told CAS and what she's telling the police. So in some circumstances, it could be relevant and you may want to apply for it.
Footnote, one of your cases, I think you had a case where the judge held that family law documents. Tell us about that before we continue, because this one almost drove you over the edge. I remember this phone call from you from court.
Right. Now, it happened in a case of mine recently in which the trial judge did determine that the complainant's family law petition or application that she had filed
in public court.
It was a record, and one of the reasons that was provided was because as a member of public, you have to give notice to the parties that, or the parties who are interested party rather. Let's say I'm just someone in the public. I want to access the family court records. So there is a rule that says that you have to provide notice to the parties involved that we are accessing your records. And that was one of the reasons that was cited as to why it was a record, and because there was emotions involved in the application. So so she deemed it to be a record. But
and she was wrong. I'm sorry, it's a public document. It's
right.
filed in a public court file. If
Right.
I want it tomorrow, I can go access it.
Right, and there is case law on that as well, which
Right.
talks about the complainant not having privacy interest because he or she, whoever has filed this application, you're filing it in court. The clerks of the court have access to it.
Everybody.
Other parties have access to it, and it's not necessarily private. You're kind of waiving your privacy interest in filing it. So there is case law on the topic, yes.
Okay, sorry for derailing you, but that case bothered me because I'm sorry. We talked in a previous episode about the intersection. I didn't use that word. I think Joe liked that word. Between family law and criminal law. And we find a ton of valuable stuff in complainants' family law affidavits that we then can use in criminal cases.
And it's relevant, and it's sometimes very relevant that you want to, because maybe she's saying or he's saying something totally different in family court.
Well, totally. I had one case recently where in her family law affidavit she indicated how, she's seeking, among other claims, damages, because that's a recent thing in family law, for her therapist and all the therapy she's had to undergo. In criminal court, I said, so how much therapy have you actually gone to? None. Oh, I see. Okay. Right. Next question. Okay, sorry, I derailed you. Rewind the tape to where you were.
So
if you can remember, I lost track.
So I think we were talking about this and everybody should understand. So I just want to make it even more easier.
Please.
So about 276, and we were talking about this before the podcast started. When I'm explaining to my clients what 276 means and how to think about it. So let's say we're talking about a sex worker, and there's something known as twin myths. So just because somebody is a sex worker does not mean that she's more likely to consent. That's just common sense.
Right.
The other thing is that just because she's a sex worker does not mean that she's less worthy of belief.
Right.
So I think that is the most easiest way to put it. So that's the twin myth that you cannot,
put to a complainant.
You cannot put to a complainant that, just because you consented to have sex with me on Thursday, so you consented to have sex with me on Friday.
Therefore, I'm innocent.
Therefore, no, that's barred. You're going to be barred from using that theory, that kind of thinking. So that's why 276 is very important. You have to go back, you have to think, you have to be specific, and you have to understand the relevance, and you're not supposed to go to the twin myths. That's 276 for you. 278, like I mentioned, it's the privacy interest of the complainant. It could be her therapy records, psychological, employment information stuff, which is very, there's a term that they say, is it like to her biographical core? Something which is very personal to the complainant. Yeah, so there's basically, if there's a lot of sensitive information in relation to the complainant, let's say social security information, I guess.
I'm still trying to get over that phrase.
there is this line, and I remember reading this, and I've just been trying to make sense of it. Yeah, I've been trying to wrap my head around it for a while now, but the most easy way to put it is sensitive information in relation to the complainant. If she has put up something on social media, and she's putting up and she's talking about it, she's waiving her privacy interest. Mm-hmm. That's not a record. or well, at least you can make an argument that it's not a record.
Right.
And she has no reasonable expectation of privacy because she's talking online.
Right.
So that's 278. Now, jumping ahead, and tell me if you want me to stop and if you have any questions.
I'm sitting here just soaking it all in.
Soaking it all up.
Yeah.
No, it's funny because we do this almost every day in one or the other case of ours. Like it's bread and butter at this point of time.
But what's fascinating, I'll just pipe in, like a lot of lawyers will just fill out a basic template.
Yeah. Oh no.
Tell us that nonsense.
No, I don't like to do templates.
Each of your applications are basically customized, handcrafted. It sounds like
my applications. It makes me laugh sometimes. They're like 400-500 pages long, and I'm like, how did I write so much? It happens, no, because the complexities of each case they're different.
Right.
So because let's say in some case you're dealing with full-on sexual intercourse and
right.
Varying difference of violence and a really lengthy history between the complainant and the accused. Some cases are not so complicated. They're like the touching, right. Like exterior touching, and just the amount that the materials that you have in a short relationship may be very different
right.
in a long relationship. But yeah, you cannot use a boilerplate application. In order to be successful and in order to be able to convince the judge as to why your materials should be in, you should be allowed to ask questions related to it. Sometimes you win cases just based on your applications.
Right.
I have materials, Crown Attorney, please see that, maybe there's some, some stuff has been omitted.
Right.
You may want to see this.
So freeze frame, what are the material, break down.
Let's break it down.
Break down, what do these materials, what am I paying for you to prepare? Describe.
Okay.
So there's a notice of application.
Oh, so you want the names of everything.
I want to know the papers that I'm spending all my hard-earned money on you to prepare. What are they?
Well, we have this whole, it's an application record, which involves your notice of application, which is basically my entire argument in writing. Mm-hmm. An explanation of what each and every item is, an explanation of why they are relevant, how I'm going to be using them. I'm showing you all my cards. This is my defense strategy.
This is what my clients provided me in terms of text messages, Instagram, whatever.
The items that I have. Some may say that it's a very discriminatory law that, as an accused, you have to show everything in your possession.
It is. Not may say. I do say. It is.
Yeah. Okay, let's go with that. It is discriminatory.
What the hell?
It is. No, but at the end of the day, it takes a lot. I don't have my application, which I just prepared today, and it's
because
upstairs.
It takes two people to carry it. That's why you don't have it here. But go ahead.
That's my strength training.
Yeah, exactly. You don't need barbells. You got your application
I got my application.
So notice of application.
Complainant statements. We get them transcribed. So the judge has a chance to review the statements before we break down the complainant statement as well, because you have to. If you don't know what prior sexual history application you're making. What is she talking about in her statement? How are the messages or the pictures or whatever I have in my possession? I put everything in. Whatever I have, I put everything in. Because I don't want to be in a position where I did not bring it and then I have to bring a mid-trial application. Because you can. Sometimes things happen in trial.
Right.
You don't, sometimes, you don't think so far ahead and the complainant says something totally new or she says something and you're like, I may have to bring an application to ask her that.
Of course. So apart from assembling the documents that your client provided you, there's also some client input. What does that look like?
It's my client's affidavit. It's my client's story, my client's, narrative of exactly what happened.
And how detailed does that get? Again, you're going to set me off on this reverse disclosure concept. But so tell us what's in there. What's in the client's affidavit? All the cards or just some of the cards?
I would think everything relevant. Everything relevant has to be there. I'm the judge.
Again.
Yeah, sure. If I'm the judge, I want to know who you are, right? I want to know what is your background, what was the relationship history, and I'm just giving as an example of, let's say, a husband and a wife, or a girlfriend and a boyfriend, or partners, and This was the relationship. This is what happened. This is how it went down. Or rather, it was going great. I don't know what happened with her.
Right.
But you got to explain everything. You got to attack each and every allegation that's been made against you. And, and that's well before in advance of the trial, and you have to explain in your affidavit as a client that this is...
Yeah, a lot of people don't get that. That's basically reverse disclosure, right? We are putting all our cards on the table.
That's what I meant. I'm not showing you all my cards.
Here's everything.
I'm showing you everything. And the way I like to practice is I put in everything. At least the items that I have in my possession, which are relevant. I don't like to be in a position where I have to bring a mid-trial application. Right. So, if... out of abundance of caution, even if I'm not going to ask questions to the complainant about a certain thing,
right,
I'll get permission regardless.
Right.
And if I were to ask, I'll ask it in this context. I don't know if I'll ask, but just so I have permission.
Right. So you've assembled everything into this giant PDF. You then email me saying, Michael, how the hell do I reduce the size of this?
Compress it for me, Michael. Send it.
Compress it so I can actually email this thing.
Yep.
I work my magic. What happens with that file next?
So we have to prepare what's called the stage 1 and stage 2. Does not matter if it's 276, does not matter 278. Mm-hmm. You're going to basically appear before a judge, and stage 1 is about whether certain conditions of the application have been met.
Trial judge, or could be a...
I prefer trial judge.
Why?
Because if things don't necessarily pan out the way you want them to,
you can appeal it.
You can appeal, yes. It's not happened so far.
Right.
I've been fortunate to have trial judges and appear before trial judges.
I've had this recent debate with some crowns where they say, well, you can bring your motion in front of a motions judge, and then we can still set a trial date far, far away. And I say, no, because there is no right of an appeal from a motions judge.
Yeah.
I want my trial judge to hear the motion.
Right.
So then if things do go south, and they rarely do, as we know,
yeah,
that it's part of an appellate record.
Right.
Right? Simple concept, but a lot of people don't get that.
And I think, and not just also from an appeal standpoint, but also from a standpoint of I prefer being in front of the trial judges because now they're familiar.
Well, you're setting the stage.
Yeah, and the rulings are given. Everybody, the Crown and I and the judge, we've all there's something, you need to know the rules of the game before you play the game. We know what we can do, what we cannot do, where we can go. The stage is prepared.
Right.
All you got to do is just put on the show.
Okay, so I've sent you back the file. You've served the Crown. You've sent the email to the court. You said stage 1. What is that?
And then
it's not a real stage, right?
You took me to a different route, but okay, I'll go back.
I know. I keep doing just to keep us awake.
So stage 1 is basically explaining.
Hey, stop. Does the Crown have to reply in writing to your application?
Well, yes.
Okay. And do they?
Most of the time. I've not had a situation so far where they've not responded. Sure, it can be a situation where if you are preparing, let's say you're getting materials from your client very last moment,
right,
and you're applying it late, you're basically filing the materials late because of whatever reason you didn't receive the stuff in time. Sometimes I believe the Crowns, if they don't have the time to respond, they may, and correct me if I'm wrong, I could be, they can just make verbal arguments. I've heard that.
Yep.
I've heard that. So regardless.
So we filed everything. A quarter of the hard work's done. We know
half of the hard work is done.
It's only a quarter. There's more work.
I like to see it half.
Okay.
I like to see it as half.
Half the work is done, and now you're actually showing up in front of the judge.
Right.
To argue that stage 1, which you've set months ago, no doubt.
Yeah, and stage 1 is all about whether the materials are capable of being admissible at trial.
Say it again, please.
Whether the materials are capable of being admissible at trial.
What does that mean? Any materials capable of being admissible?
Right, but there are certain...
You mean legally admissible?
Legally admissible. Like there are certain threshold that needs to be met. Like,
give an example.
And I keep saying this. Is it relevant? Is it relevant? Yeah. It has to be relevant.
Yes. So that's an example.
It has to be relevant. It has to be specifically, detailed. It has to be filed. The criminal code allows it 7 days in advance of the motion hearing. We like to file it well in advance because that's just how we are. And And there's one more thing that I'm missing. There's one more condition, but these are a few conditions that has to be met, and basically the judge decides whether the threshold conditions have been met.
Okay, so at the end of that exhausting half-day or full-day argument,
Half-day.
you will get a ruling, or typically not?
Well, you do. So the way I have done stage one, sometimes I've had just, my stage one has gone to a full day, even though we've scheduled it for an hour, because the oral arguments take longer than written arguments. Sometimes what you write is not sufficient.
Of course.
Sometimes you have to explain it a little further. Sometimes it just hits you last minute as to, why I want to use this for something else also.
So stage one is done. Let's say you get a successful ruling. Your client hugs you, but you say, we're not done yet.
It's not done yet. That's no, we're not done yet at all.
Exactly.
We have to go to stage two.
Same day or another day, typically?
Another day.
Okay.
Typically another day in which, and it's even more interesting stage two, because at stage two, the complainant has standing.
Explain what that means.
So let's say, you file all these materials, your partner at stage two gets to get their own lawyer to make submissions.
Who pays for that?
Government.
Okay, so appointed.
The court appoints lawyers for the complainants.
Okay.
And these lawyers, the complainant's lawyer, they're not, just so everybody understands, crowns are not complainants' lawyers. Right. For stage two purposes, complainants can get their own lawyer, the court appoints a lawyer, and what happens is that these lawyers can come and make submissions on whether or not they have an issue with certain materials that we are filing, whether they oppose it, whether they're open to their admissibility, whether they are open to being cross-examined on it, whether they have an issue with, some redactions that, you can talk about whether or not I went to my therapist, but you're not going to ask me questions about what I spoke in my therapy. Fine. That's fine.
And mandatory or optional?
Mandatory.
Typically.
I mean, if it goes to stage two and if it is... complainant, they don't necessarily have to appear in person or themselves. Their lawyers can appear on their behalf.
No, but is that required? There has to be a representative for the complainant.
If it goes to stage two and we are dealing with items which has privacy interests like records or prior sexual history.
So not optional for the complainant?
No, I don't think so.
Okay. Yeah. Okay, so this new lawyer's shown up. You're now in the courtroom with the judge, the Crown, and another lawyer. What's happening now?
Well, now is basically the battlefield where we are trying to explain to the judge why, again, I make my arguments again from stage one and I bring it to stage two and I explain, Your Honor, this is the reason why I want to use it.
Yeah, did you not hear me the first time?
Well, I'm much, much nicer than you, Michael.
Here we go.
I don't go... No, but what happens is you have to make your arguments. You have to convince the judge that I'm not going to ask her questions that are twin myth-based reasoning.
That's even hard to say after a while.
Twin myth-based
You can
reasonings.
do it. Yes.
Yeah. No, but let's say, I have these messages in which, she's the complainant, they've sent pictures of themselves that are really intimate in nature. 276 is applicable. Why? Sexual content. 278, why? She has a privacy interest. So what happens at stage two is that, like I mentioned, the 276, the 278, you have to explain to the judge why it's relevant. And I'm not going to twin based.
But haven't you already done that at stage one?
You got to do it again.
Same arguments, basically?
Pretty much.
So how do you change things up for stage two?
Well, sometimes what happens is that, you don't have to make as much arguments in stage one, because a lot of people mix up stage two arguments with stage one. And sometimes we tend to forget that, stage one, the burden is very low. Is it that the evidence is capable of being admissible?
Right, very low.
Remember that. Now, second, stage two is whether it's admissible.
Higher
whether it's admissible. Will the judge allow me to actually use it? If I want to use the complainant's petition, family court application, am I even allowed to do it? It's gone to stage two, but can it go to trial?
Right. Okay. So taller or whatever.
A little higher threshold.
Higher, yeah.
But you have to be able to explain. And the reason why I said 50% is already done is because so much time goes in preparing these applications. And trust me, I spent hours and hours just staring at my computer sometime and just thinking, how is this relevant? I'm going to be asked this question. I better have that answer. And sometimes I need my clients to explain to me, why is it relevant? How would it be relevant? Maybe what you tell me may not make sense, but maybe together we are able to come up with, maybe you won't think it, I will. And we'll come up with something that yeah, I don't think about it that way.
Right.
And it is relevant. So
stage 2, continue.
So stage
or take
2,
a sip first.
You're making me talk too much.
Yeah, well, no, we're all learning.
We should be learning from you, sir. But because we've been doing these applications for so long, it becomes second nature.
Right.
Just second nature at this point of time. So once you're done with stage 2, and let's say hypothetically speaking, all your materials are admitted,
right,
proceed to trial.
Off the trial you go.
After trial. And then again, a trial, just because it's admissible, you still have to make sure that it's relevant.
Again, I thought we just went through that stage 1 and stage 2.
I'm just not going to put something up if it's not relevant. I'm not going to, it has to be basic rules of evidence apply at trial. So just because, you've done stage 1 and stage 2, you can't just make nonsensical arguments. So just
of course. But you've already, as you said, the heavy lifting's been done by stage 2.
Then it comes down to your cross-examination. You have to use those materials carefully. You have to have a plan of action, a game plan.
Well, yeah, because the complainant's seen everything now. She's seen your cards, no?
No. It kind of depends. I've had different things happen at different trials. So,
but her lawyer is served with the stage.
Doesn't matter. Just because the lawyer has had it
doesn't mean he's.
I seek I ask for permission that only. And I've done this. Sometimes I've fought and I've said, no, nothing needs to be shown. Just, maybe give her a summary of what, we've...
Who are you talking to now? Her lawyer? Or
I'm making this argument to the judge.
No, but that her lawyer not be permitted or...
that her lawyer. There are two arguments here.
Right.
The first argument is, Your Honor, okay, stage 1, stage 2 is done. Now that, stage 1 is done, for the purposes of stage 2, please, I want a ruling from you that the complainant's lawyer do not just, hey, this is the material they filed, go through everything. So just so you know, I don't want that happening. So,
but isn't it likely that's already happened?
Well, everybody, you at least hope that there's good faith and the judge's ruling that the complainant's lawyer is not allowed to do that. And if you may concede to certain items being shown, like I don't care if the complainant has shown the family court application. I mean, she knows it. She's filed it. Yeah, she has a copy of it. I don't care for that. But if she doesn't have certain messages that are only in my possession, maybe I don't want her to see it.
But is there anything preventing legally her lawyer from viewing that?
A judge's ruling, yes. Mm-hmm. Yeah, a judge's order.
But at that point, you're already at stage 2.
Right.
Stage 1, you have filed your massive Bible.
But here's the thing. It's only when you go to stage 2, right? Mm-hmm. The complainant's lawyer is retained. So at stage 1, you know what's going to stage 2.
Right.
And when I said I have two arguments that I make, one is for stage 2 purposes, don't show her A, B, C, D, for example. For trial purposes, I ask an order, Your Honor, I know the Crown has to prepare with the complainant. Please do not show her A, B, C, D. I make those arguments depending on what the materials are. Sometimes it's really important to preserve that. Mm-hmm. Sometimes it's very important to not show the complainant. It did happen in one of my trials where I did make an argument of saying, no, I don't want to show anything. And the judge made... did speak. She basically said that you have a right to a fair trial. Right. You don't have a right to a perfect trial. Right. But
isn't the cat out of the bag by the time you're there arguing stage 2?
It is out, but what does she have in her possession? Wow. The complainant, or he has in her possession. The Crown does, the court does. For stage 2 purposes, the complainant's lawyer does.
Right. So pause. Mm-hmm. Why can that lawyer? Why can't you? Don't you assume by that point that lawyer said, "Look, here it is."
Look, it could be so. Okay, it could be so. But when the person is under cross, you'll know.
Of course.
That's how you know. You cross-examine them, and if they're very well prepared and they know what to answer and what to expect, maybe you put to them that they've had a chance to review the.
Of course, I would. You know me.
Of the stuff. And
you've studied this inside and out, I suggest to you.
It's tiring. It can be tiring sometimes. Like, to always make, each case is different.
Of course.
All the materials are different. What strategy applies where, what materials should be disclosed, should not be disclosed, how much do you have to lose if it is disclosed. You have to think about all of this in advance, which is why it's very important to sit with your lawyer, work with them, and spend time in preparing these applications and providing the information. I mean, I prepare, you provide the information.
Again, what just shows our viewers how much work goes into these. These trials aren't won by our good looks. Well, I knew you were going to do that.
No, you're pretty.
Okay, here we go. They're not won by our good looks. They're won by the massive amount of labor that goes in.
It is exhausting.
It's the tip of the iceberg, because then, you know, there's also not just putting the materials together, there's then the preparation for each stage. It's not like you're just showing up, hi, I'm ready to go. You're like not sleeping the night before stage 1, not sleeping the night before stage 2, and then, you know, it just goes on and on and on to
and
trial.
There's more work after that, because whatever
Tell us what happens after stage 2.
Whatever you have, you are able to get through,
right?
You have to use that in your cross-examination. Just because it's in, you can't just really sit on it. You have
well,
to
then you
use
have to
it.
craft a cross-examination.
You have to craft your cross-examination, and you know, you hope that, you know, the complainants are saying something which you can, you know, cross them on with your materials.
Right.
So, yep, it's a long process.
It is.
A very long process, but
it's what we do.
It's what we do. Any questions?
I've been asking the questions all night.
I'm wondering, like, do I have to break it down even further? Like, I don't know how much more.
You've broken it pretty. It's pretty broken down. It's pretty broken.
I think so. It's broken down a lot.
But the thing to remind our viewers is never ever delete these messages.
Please save them. Please save them.
God forbid any one of you should find yourself in this position, but do not ever delete text messages, photos, unless you look like a complete idiot, then you probably should delete it.
But you know what I feel bad is?
Don't delete stuff.
But you know what I feel bad is? Sometimes people genuinely don't know that a relationship is going to go south.
Of course not.
You don't know that. You're living your happy life now.
Right.
Maybe 2 years from now it's going to go bad.
Yeah, you're charged with sexual assault.
You buy a new phone, for example.
Right.
You don't know.
I've had that happen with
It's
clients
sad.
where I've asked for stuff. I think I switched phones before, you know, and I'm like, great.
Yeah.
There could have been a lot of good stuff there. So back up to iCloud, folks,
or Google Photos,
or wherever. Back this stuff up. Not like you don't
backing, and
you know, you don't sit there plotting out the demise of your relationship.
Not just that, but you know, so you have to think about it in this sense also. We're not everybody is technologically advanced. Not everybody knows how to use. Heck, I don't even know how to use TikTok. So,
let's not get started. Max is the expert on TikTok.
I don't even know how to use TikTok. I mean, I'm good at Instagram. But like, for example, you know, you're using Snapchat. The messages go after 24 hours. WhatsApp, you know, sometimes messages go. iMessages. We once had a case in which this was a sex assault of a minor, and the messages were the issue was that, you know, the complainant messaged her grandmother saying, come pick me up because this happened. And we had a full record of her text messages in which there was no message sent whatsoever. Apple iPhones are different.
Right.
iMessages are different. So she sent an iMessage, which was not discovered on the actual text messages that were sent. And that was something new. I had no idea. And I was a student at the time, so that kind of blew my mind. So,
well, thank God we have experts available who can extract that data from the iPhone itself and from the cloud if necessary.
Right.
So you've just totally exhausted me now after all of this.
I need to go sleep.
I think this is a good time to wrap things up.
Yep.
It has been very, very interesting. I hope
we miss you, Joseph. Thank you for your blessings.
But thank you for being quiet.
Joseph was channeling you very well.
I was. I didn't swear once, though. I don't think so. There will be no bleeps.
The demeanor
tonight,
was
folks.
there.
The demeanor, yeah. So we're gonna clink. And we're gonna.
Barely drank a drink.
I know I did because I was too busy.
I was talking.
We gotta do the pillow thing.
Where is it?
Yeah, this is important. Joe was so excited when I got these for us because it saves a lot of hot air. We don't have, well, we still say it, but now we can visually show it.
No, I thought it
Not
said.
donate. Well, we do accept donations and gift cards. Hey, if they want to send us Amazon gift cards, what the heck?
Yes, that'd be nice.
Don't forget to like,
subscribe.
No, you got it. The script
is
right
this
there.
My first time.
Well, okay, read it then if you have to.
Don't forget to like, comment, subscribe, and share.
Please share. This stuff's important. We just had a intake today. A new client came in, and he just hadn't seen our podcast before, and it was an eye-opening experience for him, and he's sharing it like wildfire. Please do the same. Have a good night.